All right. So a very warm welcome to all the attendees today from the phase 4 cohort primarily of the India Smart Protein Innovation Challenge 2021 and 2022 now. We started out with almost 750 participants across various backgrounds and disciplines all over India, more than 150 universities, multiple backgrounds and, common kind of interest about understanding the alternative protein or the smart protein sector, as we call it in India. And today we are in the 27th webinar session of the Inspiration webinar series, which started out in phase 2 of the challenge in this 4-month journey. And, out of set of amazing knowledge webinars that our mentors and external stakeholders from the smart protein community have been able to give us in this series are going to be pivotal and fundamental for our acceleration of the innovation of the smart protein ecosystem, both from a talent building perspective at the same time for companies which are looking to get set up in India and navigate through some of the regulatory aspects as well. So today's session is in that theme, a regulatory overview of setting up an alternative protein company in India. And you already have all received the agenda, but I'm sure we'll go through all of those bits when Nimisha and Aman kind of take over. Just quickly thanking our sponsors and partners for the challenge. So basically, this challenge is a non-profit initiative, primarily, conceptualized by JFI India, and our title sponsors Capri Global Capital Limited, NICE, Alchem Foundation, and our organizing partner CI Co at IIM Ahmedabad. We also have support from academic and research institutions across India: BIRAC, NIFTIM, SIGN, ABLE, CCAMP, CCMB, IIT Madras Bio Incubator are some of our supporting partners, and obviously a lot of market interest from angel investors, VCs, institutional funds, accelerators, incubators, and some of them are kind of laid out in our smart protein ecosystem partners, including government bodies like FIXI and Tinker Labs like Axelor, etc. So we are quite excited to have this cohort, which is interested in plant-based, cultivated, and fermentation-derived meat, eggs, and dairy products, and are working on those ideas. And for further introduction to the session, I'll invite our host for the evening, Asta, who's from our policy team. Asta, do you want to say hi and then take on the session?
Thank you so much, Shardul. Hi, I am Asta, Policy Fellow Regulatory, and I will be your GFI host for this session. We also have, as you have already been introduced, to Shardul Dabir, our innovation specialist, and we have with us Satvika Mahajan, who's our senior policy specialist and who will also be my co-host for this webinar. I'll just move on. So today's regulatory webinar is conducted by one of GFI India's Regulatory Advisory Council member, Ikigai Law. The Regulatory Advisory Council has been assembled by GFI India to provide focused regulatory advisory to the industry and to share inputs with the regulator on a clear regulatory path to market for the smart protein sector. It consists of legal and regulatory experts from India who have experience across different legal areas such as food laws, intellectual property rights, company and general corporate laws, and other legal compliance requirements needed to operate a food business in the smart protein sector in India. Ikigai Law is an award-winning law firm and has a market-leading regulatory, policy, and commercial law practice for technology and innovation-led businesses. Ikigai provides legal and strategic advice to a wide variety of clients, from high-impact startups to mature market-leading companies. Ikigai Law's expertise spans diverse sectors, including food tech, health tech, data analytics, digital payments, aerospace and aviation, artificial intelligence, and others. Today, we have with us from Ikigai Law, Nimisha Dutta and Aman Taneja. Nimisha is a counsel at Ikigai and regularly advises on venture capital and private equity investments onshore and offshore. She particularly enjoys working with startup entrepreneurs, understanding their businesses and products, and helping them navigate through various stages of funding and complex structuring advisory. She was recognized as one of leading legal practitioners under the age of 45 in India by Indian Lawyer 250. Aman Taneja is Senior Associate at Ikigai and is an experienced intellectual property and technology lawyer. At Ikigai, he focuses on legal and public policy issues, on online content, intermediary liability, privacy and data protection, alcotech, drones, and smart proteins. In the past, he has also advised smart protein companies on complying with labeling and advertising requirements, as well as on making policy recommendations on the nomenclature of plant-based milks or drinks. A very warm welcome to you, Aman and Nimisha, and thank you for being a part of the Inspiration webinar series to share your insights and with our participants. In today's webinar, Nimisha and Aman will provide a landscape of regulatory considerations to establish a smart protein company in India. The presentation will cover necessary regulatory and legal aspects of setting up a food business in India. The presentation will begin by discussing the types of business entities to determine the company model best suited to you and its incorporation process. It will then detail the eligibility criteria for startups and the benefits offered by Government of India for startups. The final section of the presentation will include potential points of considerations for an entrepreneur, such as essential clauses in a commercial agreement and co-founders agreement, regulatory compliances required for a smart protein company, and essentials from the e-commerce rules and advertising guidelines that the smart protein companies should factor in their marketing plans. But before we begin the webinar, I would also like to point you towards GFI India's startup manual, which can be downloaded from GFI India's website. As many of you might know, the manual is a dedicated guide to help smart protein entrepreneurs realize their startup food dream and has detailed sector-specific legal and business insights to help food entrepreneurs take their product to the market. We'll drop a link in the chat for your reference. With that, I would now like to invite Aman and Nimisha to present and start the webinar.
Thanks so much, Astha, for that introduction, and to the entire GFI team for giving us this opportunity. I'm very quickly going to share my screen, so I might not be able to see what's going on, but Nimisha is, I think, going to do the bulk of the talking today. And I mean, I'll hand over to Nimisha in just a second. And Nimisha, please let me know when you'd like me to, move to another slide or anything along those lines. So yeah, with that, let's get started straight away.
Thanks, Aman, and thanks, Asta, for that very well thought out and detailed introduction. Hi, everybody. Nimisha here, and I don't think I need to spend more time introducing myself for Ikigai. Just want you to keep in mind that we as a team, along with GFI, love everything which is related to innovation, technology, and entrepreneurship. So let's keep this session as interactive as possible, and let's make it a fun and inclusive session. So, Aman, we can start. So we are basically going to talk about the story of a startup and how it evolves from the stage of incorporation till you reach the stage of doing your commencing your businesses and what kind of hurdles that you may typically face. Obviously, we can't cover everything that needs to be covered and spoken about. So we've taken and culled out a few of our good practices and few of our experiences that we have faced with our founder and entrepreneurs during our journey in Ikigai. And you can move to the next slide. So the first question is to be or not to be a company. I mean, that's the fundamental starting point. I mean, I've often had founder friends who've come to say that, let me just start with being a sole proprietor. Let me just start being an LLP. What is an OCPA all about? Do we really need to be a company? There is so many hassles in being a company. There are so many compliances. Why do I need to take the cost? So the first and the foremost question is, what kind of business entity should you be? And at this juncture, I would want to pause and say that it has to be a well thought out and a foresighted plan rather than just incorporating a business and moving along. And there's a reason why I say that. As you would know, as part of the cohort of GFI and the funding processes that you may or may not have been a part of already, there are certain requirements that an investor comes with. There are certain requirements that a business comes with. There are certain requirements that a commercial agreement with your vendor comes with. And so you need to think through all of those things before you actually incorporate an entity. It's very easy, for example, to start a sole proprietorship, but it may not serve you in the long run. And I'll take you through the reasons as to why. Now, as you would know, there are several types of business establishments that can be created. One being sole proprietor, one is being limited liability partnership, one is a private limited company, and one is a one-person company. And let's go through each one of them and understand what it actually means. Sole proprietorship, one of the oldest forms of business establishments, the regular shopkeeper, the regular tax guy, the regular CA, they all usually have a sole proprietor. Why? Because it's the easiest to establish. There are no registrations required. There is no incorporation certificate required. You pretty much just start your business. And all you need to do is have the license to commence the business. So one person owns everything. It is literally you sitting in at the desk and starting your business. Your income, the entire income of that business will be reported as your personal income. However, even though it comes with all of the ease of doing the business with no annual reporting and no registration requirement, it makes raising of capital really, really difficult. It also makes scalability of business very, very difficult at certain stages, because there are certain bigger vendors, there are certain bigger suppliers, there are certain commercial establishments who do hesitate to do business with sole proprietorships, right? Because the company with a separate legal entity comes with a certain amount of gravitas, it comes with a certain amount of checks and balances, which the proprietorship lacks. Now, coming to the second type of entity, which is the LLP, which was introduced recently in 2008 by the Limited Liability Partnership Act, requires two people. And the good thing about an LLP is, and it's being preferred as one of the most suitable entity formats in the startup ecosystem, is because an LLP can be easily converted into a company at a later stage. Though it has all the advantages of being a company as it is a separate legal entity, it comes with a lot of inherent flexibilities and simplified compliances, so to speak, right? Again, a lot of my founder friends, a lot of my founder clients have incorporated LLPs and then converted them into private limited companies as and when required, mostly because of funding requirements. I'll come to the company as the last, but I'll take the OPC or one-person company the first. OPC was again introduced as a recent phenomena under the Companies Act 2013, where only one person can just incorporate a company. Now, although it seems very attractive, that you can just pretty much have no two director requirement, no two shareholders requirement, have one person company. The annual filings again are much more simple. One person company also presents a certain number of hurdles, because at the end of the day, you cannot have more than one shareholder or one member in one OPC. So therefore, the funding, when you reach the stage of funding, whether it be angel, whether it be bootstrap, whether it be friends and family, you really can't issue shares to anybody else. So then it's short-lived in that sense. Now, lastly, coming to the concept, the structure of a company, as you would all know, a private limited company is one of the most preferred business establishments, even though it comes with a number of annual and biannual compliances. It has its own tax requirements, own ROC filing, incorporation certificate, etc., etc. It is definitely one of the most preferred business establishments after LLP, because of the very fact of the ease of doing business through a company with third parties and also be able to raise the funds. Aman, we can move to the next slide. Now, I'm just going to go over some of the basic pointers to incorporate a company, and they're pretty much similar in case of an LLP and company. Obviously, for a company, you have to look at the Companies Act 2013, whereas in case of an LLP, you'll have to look at the procedure, another LLP Act 2008. Now, you can it's all in the name, right? At the brand that you create. So the first and foremost practical thing to do is to reserve your name. So under the ROC, you're allowed to reserve the name of a company or an LLP prior to even the incorporation. So you can suggest a few combinations, up to 6, and you can file that. And then whatever is chosen by you at the end, you can file it in the ASPIC form. In case of a company, you necessarily need to have a DIN. That is a director identification number. In case of an LLP, also a similar thing is required. You also would need to have your digital signatures for directors, because this is required in the forms that you file with the ROCs. Unlike before, ROC incorporation certificate can only be given once the ROC form is filed and submitted with the right amount of fees. There are certain cases in which I've seen ROC comes back with suggestions, and it's my recommendation that typically we just file the MOA, AOA in a standard language. But if the ROC does come back with suggestions, the easiest and the fastest way of doing this is to accept the changes and file those with the ROC. Most times founders also do not pay attention to making the seal of the company Now, if you take a standard MOA or the memorandum or the articles of a company, unless your articles specifically say that a seal is not required, in all your share certificates, you would need to affix a round stamp seal, the red seal on the share certificates, right? The Companies Act only says that you can avoid putting the seal on the company if your articles are not providing for it. And then you can have 2 directors sign the share certificate. So most often what I found is that, when the companies are actually doing the funding or are issuing share certificates, they say, hey, we don't have the seal. Nobody ever told us. But it is one of the most simplest things to do right at the very, very beginning, so that tomorrow when you are actually issuing share certificates to third parties or even to your own founders, to yourselves and the other existing shareholders, you have the seal ready. And then you commence your operation. Aman, we can move to the next slide. Now we come to the question, are you really a startup? Just because you believe so, does it make you a startup? No. Any company that is incorporated does not automatically become a startup. There is no statutory definition of a startup, but DPIIT, the government of India, has provided certain eligibility criteria for companies and LLPs to become startups. The reason why it is important for you to understand and for all of us to understand that why this is required is, it is not a mandatory requirement, but it's a good requirement to fulfill, because there are a number of benefits that flow from this, including a single window clearance under labor laws, such as the Gratuity Act, such as the Migrant Labor Act, such as under the Air Water Pollution Acts. They become very, very simple to comply with. A number of labor clearances also, inspections become fall off, and the inspections can only be made if a complaint is registered and approved by the Labor Commissioner. There are no inspections therefore for a period of 5 years. Promoters also are eligible to get ESOPs if once you get recognized as a startup. And there are a number of IPR processes that are simplified and subsidized once you're recognized as a startup. Now, how are you going to get recognized as a startup? One, only companies and LLPs are allowed to apply for this. You should be less than 10 years from the date of incorporation. Your turnover should be less than 100 crores. You should be working towards innovation, development, and improvement, which I don't think is a problem for any of you. And you should not have been formed by splitting or reorganization. There should not have been an old parent entity which splits its avatar into, thanks Satvika for that, splits its avatar into a smaller entity and then goes for eligibility as a startup, right? So having been said, once you do get recognized as a startup, there are a number of these benefits, including the employee stock option, as Satvika correctly pointed out, which are eligible to the promoters. Aman, we can move to the next slide. So once you get recognized as a startup, what happens next? You commence business, right? So, but there are certain very, very essential things that you should have in place. Even though they may seem very trivial and they may just be like, hygiene requirements. As my experiences last 18 to 19 years, I think they are very, very, very essential for any company, especially startup and the entrepreneur community, to have in mind when you're looking at commencing a business, because it once you have these good practices in place, it just helps you to scale up and make your business more viable and not get brittled down by, or not being brought down by these small nitty-gritties at a later stage. So we're going to cover a number of these topics, like commercial agreements, what are the regulatory requirements, what do you need to do as far as the terms of use of privacy policy is concerned, the new e-commerce rules, which allegedly have made consumers' life better and entrepreneurs' life miserable, the ASCI guidelines and co-founders agreement. So, and under commercial agreements, as you would be aware, or you would soon become aware once you commence, I'm sorry, I will take up questions towards the end, specific questions on this. If you want me to stop Shardul and Asta in between and take
we can cover them towards the end. We just recommend them to keep sending them throughout the session. Yeah.
Sure. Thank you. So like in terms of your commercial agreements, there are several types of agreements that come during the evolution cycle of a company. You will have your third-party vendor agreements, you will have your supplier agreements, you will have your consultants, you will have employees, you will have marketing arrangements, you'll have strategic alliance, you'll have channel partners. All of these agreements may sound very obtuse, they may sound full of legalese, but at the end of the day, you all have to remember that a commercial agreement is at the end of the day, nothing but your commercial agreement with a third party. So you have the right, you have the flexibility to tailor that agreement to suit your business needs. I don't mean to say that you can basically negotiate through every option only in your favor. But what I'm trying to say is that in all of that legalese that is you would see in a document, at the end of the day, those are just pure commercial points, which are provided in a way or written in a way which so that tomorrow there can be interpreted for or against a party in case of a dispute. And hence paying attention to each of these provisions in a commercial agreement becomes very, very critical. And what are these provisions? The IPR. You guys are part of a cohort which is focused on innovation and technology. And therefore, for you, as you would know, your IP, your intellectual property is the fundamentally most critical aspect of any business arrangement that you would have, whether it be with a third party, whether it be with your employees, or whether it be amongst the founders. You need to protect it at all costs. You need to ensure that your commercial agreements lay it down very clearly as to who the IP is getting licensed to, who the IP vests with, whether the IP actually is owned by you or licensed by you, and what are the rights that you're giving expressly to them. There has to be no implied license to the IP that you give. Very, very critical to have, right? Some of the terms of these commercial agreements will also talk about non-compete. Now, when you're doing a third-party agreement, let's say with a marketing agent or a channel partner who's helping you do strategic alliances with third parties, you also need to be very sure that you will be sharing the confidential information with these third parties. Now, when you share confidential information or give a pitch deck or a glimpse of what your IP looks like or what you're working towards or what your end product would end up looking like, you also need to make sure that these guys or the third parties are not able to infringe or start a competing business. And that's what is meant by non-compete. You need to make sure in those commercial agreements that it's very clearly laid down that you do not have a right on any of the confidential information, any of the intellectual property that I am going to share with you under this agreement, and you will not start a competitive business to mine, right? Termination, I think, is self-explanatory. You need to make sure that you have very specific rights on termination, what is going to happen, when, how termination is going to get triggered. One of my recommendation has always been on any commercial agreement that you should have a termination clause by mutual agreement. And what do I mean by that? Typically, people always think that an agreement will either expire on a breach of a particular provision or on the expiry. However, with COVID-19 situations, with a lot of these acts of God, which are not under our control, it is always better to have a very generic clause which says, hey, if we mutually agree with each other, we should terminate and get out of this arrangement. At the stage of a startup or an entrepreneur, an early stage entrepreneur, it is sometimes very critical to cut your losses and move out of a commercial agreement, right? I've seen during this last 2 years of COVID-19 situation where a number of people have been stuck in that agreement because there has been no way out of that agreement. I mean, obviously, at any given point of time, you can come and amend the agreement and say, hey, mutually, we want to terminate it. But it makes just life very, very simple if you have it from the very beginning, instead of, it going through the lawyers and them trying to say that, hey, there's no way out in this agreement, etc. Right? So if you have these very basic clauses, which are spelled out very clearly and very simply, I think it makes life very, very simple in case of a commercial arrangement. In case of food businesses and businesses such as, and the innovation products that you guys have, it's also very critical to ensure that you're not making any implied warranties. And what do I mean by that? For example, if I buy a tech gadget, if I buy a Dyson vacuum cleaner today, The Dyson vacuum cleaner comes with a playbook. It comes with a set of demo instructions, and very clearly with no holds barred, it says, you are getting what you are getting. We are making no promises on this machine. You will use it. If you use it by the instruction, it will do these XYZ things. There is nothing that is implied. It doesn't say that it is going to make your house sparkling clean, although its end purpose is that, right? So similarly, when you are trying to put your product out there in the market, you have to be very clear in terms of what type of purpose, what type of warranty are you giving with that product? What type of shelf life are we talking about? What type of end users are you talking about? What kind of benefits are of this product? What kind of sourcing of this product has been? It has to be very clearly laid out. Now, if you remember from your previous sessions on the regulatory landscape for the alternative protein industry or the food industry, all of this ties up to the way the commercial agreement is structured, right? Because even there, it very clearly says that your labeling requirements have to be very, very clear. You have to tell the consumer what you're putting in. You have to make the consumer, the layperson, aware of what they are getting. Similarly, in your contracts with third parties and vendors, it has to be very clearly, or your end customers, you have to be very clear as to what you are providing, because all of this is tied up together, right? The next provision, which I think is very, very critical in commercial contracts, is to make sure that you are not liable for damages, especially for your third-party suppliers and vendors. So tomorrow, nobody can stand up and say, hey, I gave you X, Y, Z, and I want 10X of what you paid me as a service fee. No, my provision, my contract should very clearly say, in case of a breach, if I am at fault, I will only owe you what you have given me in the contract. I am not going to owe you damages which are 10X of what you have paid me. I think that is a very, very important thing to keep in mind. Coming to dispute resolution, I think, again, it's self-explanatory. You should ensure that your contracts have a very clear provision which state that, hey, in case of a dispute, this is how we are going to resolve the dispute. In smaller contracts, I would advise don't go into the arbitration model, but in contracts which are of higher value, do look at arbitration as an alternative mechanism. Do specify the courts that you're going to go into. Typically, the thumb of rule that is followed is you choose the venue, or depending upon, supposing if you are the entity that is formulating the contract and negotiating the contract, you from the very beginning will say, I will do the disputes, or I will resolve the disputes in the court which is near my place of registration or my business of operation. I am not going to go to a third venue, spend money, incur the cost for resolving the dispute. And you should push for that to a large extent. Now, the last subtopic is about enforceability of electronic contracts. Now, most of us know that, WhatsApps and Instagrams and, emails have become a very regular way of communicating, doing business. And therefore, a number of questions in the recent past have been held on whether a contract really needs to be signed in the typical conventional way of a contract, whether a WhatsApp message of saying I agree actually amounts to a contract. Now, there are conflicting views on it, but the Supreme Court has in the recent past held that the ingredients of a contract remain the same, whether it's in physical form or electronic form. If there is an offer made and there is an acceptance of that offer, right? If I ask you, will you supply me these goods? And you say, I agree. And we have agreed that this is going to be the price for that, right? And there is no deviation from those basic principles. Then an electronic contract is also enforceable. So is a verbal contract for that matter. The reason why we put it down on paper is to make sure that tomorrow, if there is a dispute, we do not waste time and resources in trying to establish the authenticity and the bindingness of that contract. Aman, we can move on. Coming to basic regulatory compliances, I think most of you would be aware of some of this already. We've covered incorporation a short while ago. Startup registration, again, is something that we touched upon. GST registration would become important for most of you commencing businesses. Registration under the Shops and Establishment Act and certain labor laws also becomes fairly critical. The Shops and Establishment Act also governs the way you provide your leave and the leave policy of a company. So the Shops and Establishment Act is a state legislation. There is no central government legislation on this. So depending upon where you are placed or incorporated, for example, if you're incorporated in Haryana, there will be the Punjab Shops and Establishment Act that will govern you. But if you're incorporated in Delhi, it has its own specific Shops and Establishment Act, and they provide the basic threshold that you have to comply with. You can always, as a company or an entrepreneur, go above that threshold. However, the Shops and Establishment, most labor laws provide the basic threshold that needs to be complied with as far as labor law is concerned. Again, IP registration is something that I believe that you guys would be already aware of, that, you know, if there is a particular tech-based IP that you would want to register, it is always a good idea to have the IP registered. Copyright is automatic. Trademark also becomes vested in a company or the entrepreneur based on usage. But what registration helps with is to establish the authenticity and the bindingness of this intellectual property without having to go into the whole process of, you know, I need to prove this to you. One more compliance that has become fairly important and I think is overlooked by a number of startup entrepreneurs is the POSH, the Prevention of Sexual Harassment at Workplace Act requirement. Every establishment needs to have this in place. It's a very simple policy. It has certain annual compliances along with the ROC filings, but it is something that you need to, and I cannot stress enough, have in place. Registration and compliances under the FSS Act is something I believe that has been covered in the previous cohort, in the previous sessions with you, and maybe we can touch upon this if you guys have any other questions or any follow-up on that. Aman, we can move to the next slide. Thanks. Coming to website terms and use and privacy policy. Now, there is no law which requires you to have a terms of use in place. I mean, you can have a website, but you can choose not to have a terms of use in place. There's no law saying every company shall establish terms of use. However, the law does say that you should have a privacy policy in place, right? And I'll tell you the difference between the two. The terms of use is for people who are just visiting your website. They are just, they may or may not end up buying your products. They may or may not give you any information, but it is a good practice to have because it establishes a certain boundary within which the company operates. It establishes a certain amount of do's and don'ts that the company would have in place in case the user, in case the person who's browsing comes across certain information in the company. For example, all of this again ties up to the principles that we've discussed for contracts, for example, such as warranties. So the terms of use will say, hey, if you're looking at any product from our website, there's no implied warranty. If you are a person who's a user, you are definitely bound by this contract because terms of use at the end of the day is a contract between the person who's entering your website and the company. But in case you're just browsing, it still binds you. The terms of use would direct you to the dispute resolution that we discussed for commercial agreements. It will direct you towards that, you know, the company is not going to be liable for any damages, the damages that we discussed in commercial agreements. So it will discuss a number of these things, including the content of the company which is being displayed, whether you have a blog on, let's say, alternative proteins, whether you have an article which is published, whether you have your services which are provided. In addition to our terms of use on a particular website, privacy policy also assumes, privacy policy also assumes great significance because what the privacy policy actually does is that it lets the user know that this is the type of information that we're going to collect for you. This is the purpose that we use the information for. We are going to take your consent before we do anything beyond this purpose. We also give you the opportunity to take these forms of information down. It also establishes the boundary once again on the liability that the company would have as far as those information usage is concerned, and whether you are able to use third-party websites and sites and whether you hyperlink those within the websites. One of the mandatory conditions of a privacy policy under the applicable law, that is the IT Act, is that you have to nominate a grievance officer. Now, this person can be anybody in your company. This can be a co-founder. This can be yourself. where the person who's coming on your website knows who to reach out to in case there is an issue tomorrow on the type of information that is collected and used by you. Aman, we can move to the next one. Coming to the next broader topic of e-commerce rules. Now, the e-commerce rules were introduced to protect the interest of consumers and prevent the exploitation and encourage free and fair competition in the market. E-commerce rules are very, very broad in their scope. And so e-commerce literally means buying and selling of any good or any services over a digital or electronic network. I sincerely believe that there is literally nothing that is left out there which doesn't fall under the concept of e-commerce unless you have a brick and mortar shop and nothing else, right? So if you are on any kind of social media network, any kind of digital platform, and you're providing or advertising or selling a product and your services, including marketing or services, you will fall within the scope of these rules. Now, why is the e-commerce rules actually important? Because it lays down very clear and specific obligations to ensure that the consumer is very well informed and that there is fair and free market competition between entities, right? There are very specific mandatory requirements under the e-commerce rules, which say that if you are selling anything on a website or on a digital platform, you are going to provide the details of the entities, of the addresses, the grievance officer, the country that you're exporting from, the name of the importer, all on the website so that the consumer knows what it's getting. We should not adopt any unfair trade practices in the course of it also mandates that there should not be any unfair trade practices which should be adopted in the course of business, and that there should be an adequate grievance redressal mechanism that is presented there. And this is along with your PP policy, right? So if you have that established as far as the privacy policy is concerned, you would be covered here. You don't need to appoint a second person. One of the requirements here under the e-commerce rules is that the grievance officer will have to respond to the consumer complaints within 48 hours. Aman, we can move on. I've already covered the details of the import. One of the things that is very, very critical under the e-commerce rules is that when you're taking consent from your consumers in any format whatsoever, it cannot be consent which is adopted automatically. It has to be a consent which is an express consent. And what do I mean by that? Express consent means where the person like you and I are able to read, understand, digest, and agree to that consent. It cannot be a pre-ticked checkbox. It cannot be a small pop-up which just says, hey, hi, I agree. It needs to provide me explicitly, and it needs to take my consent affirmatively and explicitly, right? As a part of the e-commerce ecosystem, you also need to have your payment mechanisms as per applicable law and RBI guidelines. ASCI is another important concept that needs to be kept in mind. ASCI, though has been popularized as a voluntary code, is not really voluntary in nature. And Aman can take you through some of the important aspects of ASCI.
Thanks a lot, Nimisha. I'll actually just very quickly, for the benefit of the larger group, even though on the last section on the e-commerce rules, just one point to add is that that set of rules is under the larger ambit of the Consumer Protection Act, right? So there's a separate regulator called the Consumer Protection Authority, and which can really look into sort of consumer complaints and disputes. And I suspect for a lot of the businesses that are sort of going to come out of this cohort, they are going to be consumer-facing products, right? That's why it's important to understand. I think the Advertising Standards Council, like Nimisha was saying, is a self-regulatory body which has been sort of set up by the industry, but it has in certain, especially for say television ads, it is legally recognized by the rules for television ads by the Cable Television Network Regulation Act, for instance. And so and advertisements are it's something that everybody does, but perhaps you don't give enough thought to it. The ASCI looks at ads across media, right? So it's not just limited to print or television, but even stuff on social media, even stuff on are all covered under that. So why, first question to answer is, it might not technically be legally binding, but why should you comply with the Advertising Standards Council code? It's kind of become the de facto industry standard. Everyone complies. They claim to have sort of a compliance rate of well into the 90%. If there's ever a issue with an actual regulator, with a court, or with say a body like the FSSAI or the Consumer Protection Regulator, ASCI recommendations or observations from there do have sort of persuasive value. So it's good to keep them on your side. And I think the biggest reason, specifically for companies which are in this space, is that the Advertising Standards Council can send its recommendations to other regulators. And in fact, they actually have a memorandum of understanding with the FSSAI to do the monitoring of food and beverage advertisements on behalf of the FSSAI, right? So the ASCI is given that mandate to monitor ads for compliance with a lot of the FSS Act. And I do understand there's been a separate session on this, but there are specific FSS Act rules on advertisements, on the sort of claims you can make, on packaging and labeling requirements. All of those are also things that the ASCI can sort of have a say in. So that's why it becomes all the more important. There are largely these sort of 4 principles that is covered in the code, but and it's fairly easy to sort of break it down into what those constituent elements are. You have to be honest to your consumers. You can't mislead your consumers. You shouldn't things shouldn't be offensive or vulgar, especially in how you depict women. So a lot of the I think the deodorant ads that we've seen in the past are the ones which kind of trip this requirement. And there's some really like specific things, like if you're showing someone driving a car, then make sure they're wearing seat belts. People shouldn't be shown without helmets, stuff like that. So you shouldn't encourage any dangerous behavior. And the last chapter deals with being fair in competition. So there are guidelines around how you should do comparative advertising, etc. You're allowed to make comparisons, but there are certain rules to that game. So it's an important thing to sort of factor in as you're thinking about advertising and marketing. And for food companies specifically, I would say it's really important to think about what are the sort of claims that you can make, right? For instance, regarding how your product tastes or what its nutritional value is. Again, on nutritional value, there are specific FSS guidelines which lay down what can be said. If you want to say something is low calorie, then there's it can only be where it's below a certain recommendation. And by and large, everything needs to be backed by some sort of study to establish that. In general, rule of thumb with the Advertising Standards Council is that if you're making sort of any claim that X has this much nutritional value, or Y has contains this much sugar or protein or whatever it is that you're trying to, it should be supported with some sort of independent study scientifically establishing that, right? It becomes really important. And we can talk about a few examples that we've seen in the past for, it's not something that's happened a lot with, because this is a newer industry, we don't have too many examples of sort of at the Advertising Standards Council looking into alternate protein companies. But there was, for instance, one company which had made a certain claim regarding it tasting a certain way. And the evidence that they had to support that was a lot of consumer testimonials, like literally in the hundreds of those. And the ASCI raised a complaint, and the company responds with those consumer testimonials saying, everyone says we taste amazing and we taste like this. And but the Advertising Standards Council wasn't convinced. They like having studies. They like having someone sort of independently verify these things. So it is important that if you're making any claims about nutritional value or taste or any of those sort of parameters, you have something to back it up with, right? I will say this, that the ASCI does recognize what I mean in law is known as puffery, is like to say that my product is the best in the world. So those sort of claims are allowed, but they are, if you're saying I'm the taste, I mean something like I'm the tastiest, that should be okay, but they are a little, you know, cautious. They prefer having something to back it up with. So all the stuff which is obviously not true, which is a clear exaggeration, is something that should be okay, but it should be very clear in your sort of advertising material that this is an exaggeration. Someone shouldn't take it to be true. Right. And another thing to sort of factor in, and this is something that's sort of a newer development, is that the ASCI now has specific guidelines for using celebrities or influencers in your marketing. And if you're paying a social media influencer, for instance, to you know, promote your product, and you may not even be paying them, you might just be sending them free samples. Even that requires there to be certain declarations. And a couple of months ago, they've in fact, the ASCI has come out with a list of defaulters, including people like Ranveer Singh, Jacqueline Fernandez, for, you know, not complying with this requirement of declaring to consumers that this is a paid promotion or this is a promotion along those lines. So again, that's something to factor in. You need to sort of be honest and upfront with your consumers. And advertising and how you project your products are I mean, that's very important. And these decisions by the Advertising Standards Council do get reported. They're public documents, which, you know, and as Nimisha might talk about this a little bit more, but when you do come to a point where, you know, you're looking for funding, etc., these things will show up in reports that someone is doing a due diligence into you. It does have a negative effect on perception in general. So it's best to sort of err on the side of the caution and proceed with caution when you're advertising. I'll pause there, and of course, if there are questions, we can take them up later. Nimisha, over to you.
Yeah, thanks for that, Aman. Had very interesting comments while your session was on. Red Bull gives you wings is one of the comments. Yes, those are precisely the kind of exaggerations which are allowed, because those are very obviously not true. Coming back to slightly not so interesting topics, but very critical, is the Founders Agreement. Now, this is the last part of the session before we break and we take the Q&A. The Founders Agreement just falls short of a shareholders agreement. And the reason why I take this up towards the very, very end is because even though it's not mandatory, and a number of founders do not think at the stage of innovation or ideation as the Founders Agreement being important, do realize the importance of Founders Agreement, especially when your angel funding or your funding is slightly far away, right? And it's not something that you're immediately thinking of. The reason why I want to stress on a Founders Agreement is because I've seen certain relationships among co-founders turn sour. And when you know that funding is slightly away, slightly far down the road, and that you are not going to really look at, and you're still bootstrapped, it sometimes becomes, it's a good practice to have a simple Founders Agreement in place. Although this may seem a lot of legalese again on paper, it actually boils down to something very, very basic, as that you have very clear roles and responsibilities of each of the founders in place. You make sure that your shareholding pattern, if there is any lock-in between the founders and the shareholder on the shareholding pattern, that's specified. How are you going to look at transfer of shares? Do you want to have any exit strategy between the founders? Do you want to buy off the founder when they actually want to leave the company? Again, coming back to things that we discussed as a part of the commercial agreement, do you want to have a non-compete on the co-founder that, trade your boat together, but tomorrow there's no competing business that gets started? How are you going to really look at the governance of the entity that you have formulated, whether it be an LLP or a company? Decision-making process for the startups becomes very, very important. I'm just going to leave these thoughts with you. Like I said, all of this may sound a lot of information, a lot of legalese, but at the end of the day, these are they're in principle very simple concepts, but they're very critical concepts to have in place. So it makes your journey as an entrepreneur in your startup simple and more efficient. Thank you.
Thank you so much for that wonderful session, Nimisha and Aman. I'm sure the participants have a better insight into the regulatory overview and the regulatory landscape in India as it exists today. We have a few questions which we can just address to you, Nimisha and Aman. So the first one is, I do understand that a LLP or OPC helps in raising money, but can it be upgraded from proprietorship?
So no, a proprietor cannot be changed into an LLP in a company. A proprietor would have to be bound down, and then you would have to start a new entity itself. But what can happen practically is that once you have your proof of concept in place, you have your marketing in place, you have your product in place, or your ideation more formed up, you can then transfer your assets from the proprietorship into an LLP in a company through very simple agreements. But the entity itself cannot be changed. But there are ways and mechanisms to change or turn over or transfer or assign the assets or the IP or the ideas to another entity for nominal considerations through a contract.
I just have a quick follow-up question there. So let's just say there are a couple of founders, 3 founders working as a proprietorship, to begin with, or perhaps like a partnership, because there are more than 1 people to begin with, and they are kind of in the prototyping stage for a couple of years. What would you recommend as the right stage for people to register as a, LLC or a, private limited company?
Yeah, so I've had transactions in which people like design innovation startups into the home space, right? Designers themselves, and they were partnerships. Now, at the stage of the funding is only when they decided to convert that into a company, right? And as a part of that transaction, the investors wanted all of the assets and all of the IP and the employment agreement of these founders to be transferred to the company, right? So that was a part of the whole funding process. I mean, they insisted on it, and rightly so, because they were investing with the founders and for the brand and whatever that they had created as a business. Now, if there are 3 or more people, I would recommend that they would start with an LLP itself, right? If company compliances seems to be an overkill at that point of time, because an LLP can be converted into a company very easily under the Companies Act. I hope that answers your question, John.
Yeah, thank you. Thank you, Nimisha.
Thanks, Shardul. Another question we have here, Nimisha, is what are the expected incorporation costs?
Okay. I mean, I'm not really the right person to answer that question, but I often I don't think more than it's not more than about a few thousands to maybe 10, 15,000, depending upon what kind of compliance company secretary you would hire. And you would need to have a CA or a CS in place if you're incorporating an entity, just to make sure that your basic housekeeping requirements on an annual or a biannual basis are done. I mean, it's just too much load to take, especially when you're trying to start your own business and, reaching out to people, making your pitch decks, reaching out to vendors, maintaining your website terms and conditions. I mean, it's best to leave it to the experts, because the ROC compliances are not very easy to navigate through. I mean, it really makes sense to have somebody on like a annual retainer basis to do it like on a regular process, as a regular process for you.
Yeah, I completely second that recommendation. I started out as an operations specialist with JFI India, and all the things we were discussing today, they might sound a little tedious and legal, like Nimisha mentioned, but like so critical, right? Without which you cannot really function or raise money. So another question I had was what percentage of startups that raise VC, angel, or perhaps more institutional funding in a sector like ours would be proprietorships or partnerships versus, registered private limited companies or LLPs?
So Shardul, I think entrepreneurs today are very well informed about the VC ecosystem already. It's no longer elitist, so to speak, concept to get VC funding. People are reaching out to angels at different stages, even when they're bootstraps, even at the ideation stage. They become part of cohorts such as yours and are exposed to so many people and network so well. So I think entrepreneurs today start very, very early on as an LLP or a company. I think a bulk of the industry, whether it be food-based, whether it be based in just no other sectors coming to my mind immediately right now because I'm talking to you guys. But yeah, I mean, bulk of the entrepreneurs are already into LLPs and companies. I see very few proprietorships coming through.
Yeah, makes sense. Yeah, thank you. Thank you.
Nimisha, there's another question here on, is there a timeline where LLP may not be converted to private limited?
No, the Companies Act doesn't specify.
Right. Also on startup, is there a minimum revenue clause in the criteria to be recognized as a startup?
No, you shouldn't be above 100 crores. You shouldn't be a big company.
So the question was basically, if we are arguing for the case of us being a startup, are there any scenarios that you've seen that, you know, a small team or early stage startup might not qualify as a startup per se?
No, I think it's a very simple process, Shardul. It literally takes 2 to 3 days to get the recognition certificate. I do not recollect any particular startup that has not been recognized. There's been only one case in my experience in the last couple of years where there was a clarification sought because that entity had an affiliate in the US and they were turning into India. They were flipping back into India. So they were asking whether that was actually a reorganization of sorts, right? Because you can't split up from a already established business and then to claim benefits under the Startup India program, you know, establish something in India and say, hey, you know, give us now all the subsidies and income tax exemptions, etc.
Makes sense. Yeah. Thank you.
Yeah, thanks, Nimisha. Another question, at what stage should we move to creating a formal entity? At ideation or research level or product development?
That really depends upon your bandwidth, frankly, as an entrepreneur. The reason why an entity is preferred is because it helps you get a foot in the door with a number of people, whether it be third-party commercial agreements, right? Through a vendor, through a big supplier, to end customers, or even with your funding requirements, right? I may not be able to enter in many places just by saying Nimisha, but if I have something like quirko.com on my card, it sometimes just makes life easier to have that you've thought through the process, right? You have pitch deck is formalized. You appear more professional and formal in that sense, though it's not mandatory. I mean, a lot of people have succeeded as individual entrepreneurs as well and then gone to establish formal entities, but I think it really depends upon your appetite and your bandwidth.
Yeah, understood. Makes sense. Can you share how promoters become eligible for ESOPs?
Sure. So under the startup scheme by DPIIT, recently startups for a period of 10 years are allowed to issue ESOPs to their promoters. Now, under the Companies Act, an employee stock option is only possible for its employees, not for its promoters, not for people who incorporated the company. But this has been relaxed for startups because I think Government of India does realize that more often than not, a lot of founders have to dilute themselves to a large extent when they raise funds. And this helps founders to get some incentives through the investors. But supposing if you have a 10% created on your cap table, right? The investors can say, hey, as a next incentive, if you achieve these milestones within, let's say, the next 3 annual business plans, we'll reserve this 2% out of the 10% for the promoters. But this is only possible for the 10 years from date of incorporation. It is not possible for the lifetime of the company. So just to provide incentive to the promoters to be able to get ESOPs as well.
Yeah, thanks, Nimisha. That was helpful. On contracts we have, how do we see smart contracts, which are blockchain based, shaping this up in the food sector in the next few years? And maybe Shardul can add a little context to that.
Yeah, earlier, Nimisha, you were basically talking about, the utility of contracts for multiple aspects of, running a business, and especially talking about traceability and perhaps more blockchain-based applications. How do you, because I know Ikigai also works in the blockchain domain, so just figure out might be a good question here. You're on mute, yeah.
Sorry for that. Yeah, blockchain, like any other industry, I think will help the food sector as well, because it will help improve food traceability. It can prevent price coercions, improved inventory management, labeling requirements. I think these are some of the issues that are faced by this sector. Supplier selection, again, all of these will definitely become slightly more streamlined if blockchain is adopted. And smart contracts adopted. Aman, do you want to add to that?
No, not particularly. I think, like you're saying, there are different use cases for smart contracts, and traceability, I think, is a great example, which is quite relevant to the food space. But yeah, I mean, if there's a slightly more specific question, I think we can take that. There's definitely no end to the sort of different use cases and applications. And as Nimisha was saying, electronic contracts, as long as those elements are met, they're sort of also legally recognized. So and the good thing is they're self-executing in the sense that it'll go through on its own. So yeah, makes life easy. But yeah.
I mean, the very fact that blockchain contracts, I mean, smart contracts have a community-based check and balance goes a long way in any industry, right? So when there is a community-based inherent check and balance created for the life cycle of industry, it will help you address the various trigger issues in each of these. Each of these trigger issues. Sorry.
Yeah, for sure. It's my personal thought as well that I think for food industry related companies with a lot of supply chain and a lot of aspects of ensuring that the contracts kind of self-executed would really cut down a lot of logistics costs in the long run. But yeah, I think we can move on in the interest of time, accepting area anyways. Yeah.
Thanks for that question, Shardul, and thanks for answering that, Nimisha and Aman. You can see from the outpour of questions how useful all the participants found this session. Another question that we have is, are the time periods for benefits described under Startup India scheme since the date of incorporation of company or from the date of being recognized as a startup?
Most of them are from date of incorporation.
Okay. There's also a general question on if you can talk a little more about government's policy on startups and how are they helping, any resources on government policies, if you would like to share any.
Yeah, if I might just add a bit to that question as well, Nimisha, so you can answer both of them. There are also startups looking at incorporating in, say, Singapore for ease of doing business or raising capital. If you've come any, examples where incorporating in India could be beneficial from subsidies perspective, etc. Maybe if you could talk about any of those examples, that might be helpful as well. Just what complexities might come up for, like you're talking about the case of startup, based out of USA and registering, in India. What kind of concerns should one as an early stage startup keep in mind? For example, maybe while having a back office in India versus, headquarters in Singapore or something like that. Incorporation.
Sure. It's actually quite a complex question, Shardul, because it really depends upon the type of industry. So the use case, for example, that I was talking about, where the US company was coming to India because the investors required it to, was actually quite a unique case, because it's usually the other way around, where the investors push you towards a jurisdiction which is outside India. The reason being is the type of industry. This was an industry which was based on Ayurvedic products, skincare, AI-based skincare analysis, and then selling Ayurvedic products for that. And hence, obviously, your end consumer is pretty much all over the world, but your focus of your business and operations is in India. Now compare that to, let's say, a crypto exchange. And I'll come to the food industry. Now, a crypto exchange, the regulatory environment in India is so uncertain that a lot of investors would push you outside India, right? And would only ask you to have like a fly-by-night kind of an operation entity in India. Because of, again, the tech innovation in India is to boast about. The people that are working here, as far as operations are concerned, are unparalleled anywhere in the world, right? So it really depends upon the kind of industry you are based in. Now, for food itself, an alternative protein market, I would assume that India is not a bad place to start, unless you scale up to a level where you need to have be headquartered outside, right? Having said that, when you look at a startup which is very sure that it is going to have a global outreach, right? It's always better to flip as early as possible. And what do I mean by that? Once you have established a business in India, and once you have a sufficient business here with a high liquidity here, it becomes more and more difficult to move outside with that entity. There are several layers of complications that get added to that, because, I mean, just to put it very, very shortly, the RBI prohibits you to take money outside India and then come back and establish a subsidiary here. It just prohibits it. So, yeah, I mean, again, this is slightly complex to just answer in this one session. I could maybe have another session on flip, but yeah.
Yeah, I mean, no, absolutely. If people have any specific questions, they can always, I think, reach out to you as well separately, and reach out to our policy team so we can connect you further with our ACT members. ASAI, I think we can take the next question.
Yeah, thanks, Shardul. And like Shardul pointed out, if there are any further questions, you can just reach out to either Satvika, Radhika, or I. I'll just drop our emails in the chat box and we'll be happy to address the queries that you have. For now, the next question is for e-commerce marketplace concept. Can the entity sell the products procured from different brands on their own platforms? Usually food products, you know, as I heard, Cloudtail, Amazon arrangement is also being disintegrated. So essentially, whether e-commerce marketplace can sell products procured from different brands on their own platform.
So there are, again, the e-commerce rules itself do not prohibit this, but it depends upon the, again, the FDI policy, and the FEMA compliances on this, because again, it depends upon whether it qualifies as multi-retail brand trading or it's single retail trading. This doesn't fall under what the e-commerce rules per se are looking at from a consumer's point of view. What this question, I think, indirectly wants to address is whether you can have a multi-retail branding or a single retail branding, and that you will have to look at under the FDI policy. And it's possible, as we see on different platforms, but you have to have a number of compliances that needs to get done for this.
Yeah, just basically, if you have foreign funding, it gets complicated. I think otherwise it's a lot more straightforward. I think the case with Amazon is that it's a foreign company. Yeah. That's why it's complicated.
Makes sense. I think we have one more question around bankruptcy laws, perhaps for startups and as well as personal bankruptcy laws, if there are any, and how are they factoring in for choice of incorporation, etc. for startups?
Sure. Guys, we're just starting out. Let's not think of bankruptcy. Yeah, just yet. But so bankruptcy makes, treats everybody equally, you, me, and the startups. It doesn't differentiate between whether you're a startup or a company or an LLP or a sole proprietorship. The new act, the new bankruptcy code, looks at both, for the first time, operational creditors and financial creditors. Operational creditors are anybody that you owe money for your general operations, and financial creditors are entities that you owe money to in case of your business, such as your typical conventional banks, your investors, and all of those become your financial creditors. And when you're incorporating a company, I don't think, or an entity, I don't think your bankruptcy issues will figure out, because you will get treated by the bankruptcy laws pretty much similarly if a case is filed against you. I hope that answers the question. And I hope I got that correctly.
Yeah, also I understand that insolvency and bankruptcy in general is a vast topic, and we could probably take that into account, excuse me, for our next session. For now, another question that we have is, what are the pros and cons of ESOPs versus stock appreciation rights for promoters?
Sure. So SARs are not very popular in India yet, right? Stock appreciation rights offer the right to cash equivalent of a stock price over a predetermined time interval. The startup ecosystem and the investor community are not very favorable towards a SAR, because at the end of the day, STAR means an assured price return to the promoters, right? It says that if you spend this much time, your stock will give you this much amount of money. ESOPs, on the other hand, still have a lot of variables in that. Is governed by the policy of the board and a law. And it says that, you will have a certain amount of vesting. You have to earn your right towards the ESOPs. There's going to be a lock-in of your ESOPs. SARs, on the other hand, gives a little bit more flexibility to the promoters to get that money out of the company. And believe me, investors don't like promoters to get the money out of the company.
Thanks, Nimisha. I believe that answers the question. The last question we have is whether business startup annual turnover of up to 40 lakhs are exempted from GST, but still businesses are insisted to have a GST registered number. Why is that so?
Sure. I think the reason is very practical. You do get a subsidy both under income tax and GST if you're a recognized startup. But I think number of times what happens is that you end up claiming credit, right, from your suppliers and from your vendors. And I think that's the reason why GST registration sometimes becomes a more practical necessity than anything else. But I'm not a tax expert, so I would urge if you could, reconfirm that answer. But I've seen that's one of the most practical reasons as to why that happens.
Thank you so much. I think we are kind of done with most of the public questions for this recorded session, and I'll invite Satvika to share any closing thoughts before we can get into the last leg for 15 minutes for a closed-door Q&A.
Thanks so much, Shardul. And thank you so much, Nimisha and Aman, for this enlightening session. It was really useful for all the participants. As you can see from the chat as well, they found the insights very, very useful. I think the larger input I would have here is also that while all of this sounds, very technical, there is a lot of jargon involved, of course. But like Nimisha also said, this is extremely crucial for any, entrepreneur that is, looking to expand, looking to, scale their operations within the Indian market. And only with a very strong legal foundation and a regulatory foundation can you think about, expanding your product portfolio or even setting up your product portfolio in place. So having this understanding, having, advisory from legal experts, regulatory experts at the right aspects in your journey is very helpful. And of course, we have the Regulatory Advisory Council members for this particular purpose as well. They understand, this sector very well. They're able to advise you on all these aspects as well. And of course, there are certain things that become even more important for smart protein companies when it comes to how you are advertising your products, how you're labeling your products, how you're protecting your IP. And all of these things, while we've covered to some degree in previous sessions, I think for this session, it was a good way for us to tie it all together and see how the entire landscape looks like. So I hope it has been useful for all the participants, and we will now use the last 15 minutes to address any other questions that we might have, which we haven't covered already in the course of the session. Thank you so much.
Thank you, Satvika. And with that, we'll close the Inspiration webinar series this year for ISPIC 2021. We had 27 sessions, and last year we had almost 22 sessions. So we have almost 50 very interesting webinars now, just as part of the Inspiration webinar series on our YouTube handle, GFI India. And you can also take a look at previous sessions at your own time who've joined us today. You can all find them on our LinkedIn handle, Twitter handle, and our YouTube page as well. So thank you so much for joining us today, and hope to see you in our future sessions.